Bathroom laws. Hey, as many of us are well aware, North Carolina has passed a law that provides that state bathrooms, those in government buildings, can only be used by people whose biological sex matches the name on the bathroom. So that means people who are transgender have to use the bathroom for their original biological sex. Okay, well, this has created a lot of controversy, lots of controversy. Some bands have indicated that they will boycott North Carolina. PayPal indicated they're not going to expand an operation in North Carolina. A lot of people are upset about this. And interestingly enough, the Attorney General for North Carolina, Roy Cooper, has indicated that he will not defend the law. He indicates he finds it to be a national embarrassment, and therefore he won't defend it. So when the American Civil Liberties Union or someone else brings suit to find that that law is unconstitutional, there's not going to be anybody on the other side defending it. No. At least there's not going to be anybody from the Attorney General's office for the state of North Carolina. So can the Attorney General do this? He's gotten lots of criticism about it. Well, the answer to the question is yes. Yes, he can do this. And whenever there is going to be an actual enforcement of a law, which is done by the executive portion of government, there's a lot of discretion. From the time the law initially is enforced right on the street level, there's lots of discretion. A police officer pulls somebody over for speeding. Well, the officer has the discretion as to whether to give the person a ticket, not give the person a ticket. Does the officer find that there's compelling evidence to warrant giving the ticket? When a criminal act is then going to be prosecuted, it's up to the DA and the assistant DA. Are they going to move forward on this? Do they find the evidence to be really pretty bad, or do they find the evidence to be pretty good? They make the decision. And the Attorney General of a state can decide whether or not they are going to basically defend in court the laws of the state. This brings to mind what took place in California some years ago when Proposition 8 was passed. Proposition 8, of course, defined marriage as only between a man and a woman. Well, when there was a challenge brought against the constitutionality of that proposition, the Attorney General for California at the time said, I'm not going to defend it, not going to defend it. The governor, Jerry Brown, said, I'm not going to defend it, I'm not going to defend it. I am not going to appoint any outside counsel, any counsel other than the Attorney General's office to defend this on behalf of the state. In short, it's just going to be out there undefended. When the case got up to the U.S. Supreme Court, one of the big issues that was being raised is, do you have standing to be here? Standing meaning, do you have a position in the law that allows you to take one side or the other? And in that instance, the court found there was some real problems with regard to the groups that were trying to defend that proposition. So the point of this is really pretty straightforward, but it's a point a lot of us don't reflect upon. And that is the executive branch of government, whether it's the president, whether it's a governor, actually decides whether or not a law will be enforced. The legislature can pass all kinds of laws, but it's only the executive that enforces them or does not. Okay, we bring you this discussion as we bring discussions every week so you understand how the law works. I'm David Allen.